Very welcome to this channel, Law Ki Bara Khadi, and we will be discussing this particular important case of Wikipedia Foundation versus any media private limited and others. It's a recent Supreme Court case which talks about the freedom of press and balancing it with the administration of justice. So if you're preparing for your constitutional law exam or any other competitive exam, तो ये particular case जो है आपके लिए बहुत important हो सकता है बिकॉज ये इन जनरल टॉक्स अबाउट द फ्रीडम ऑफ प्रेस आर्टिकल 19 के बारे में बात करता है एडमिनिस्ट्रेशन ऑफ जस्टिस विच इज अ वेरी इंपॉर्टेंट फंक्शन ऑफ द जुडिशरी उसके बारे में बात करता है तो चलिए लेट्स टॉक अबाउट द ब्रीफ फैक्ट्स ऑफ दिस केस. Now let us quickly go through how this present appeal came in front of the Supreme Court. So an original suit was filed by the respondent, that is ANI, against the defendant Wikimedia Foundation, which is still pending now. So in this particular case that was filed in the High Court in front of the single learned judge, there were two reliefs that were sought by ANI in this case. First was injunction restraining the defendants from posting or republishing defamatory content that was on the platform, and second was direction to defendant number one to remove defamatory content and prevent further publication. Now, based on these relief, now let us look at the timeline. So on order dated 20 August 2024, the High Court's single judge, he directed the defendants to disclose the subscriber details of defendant number 2 to 4 within 2 weeks. अब इस particular case में और भी defendant थी, तो विकीमीडिया को ये डायरेक्ट किया गया कि वो जो डिफेंडेंट नंबर 2 से 4 है उनका जो सब्सक्राइबर डिटेल्स हैं वो कोर्ट को प्रेजेंट किया जाए. अब हुआ ये कि विकीमीडिया ने इस चीज का पालन नहीं किया. विकीमीडिया डिड नॉट फॉलो दी स्टेप्स एंड देयरफॉर a contempt application was filed by the respondent, and it was alleged that they had done a willful disobedience to this particular 20 August का order. Now let us see that after the contempt proceedings were underway, on 17th September, an opinion piece was published that criticized the court's order and its impact on free speech. Now this was hosted on the appellant's platform, that is Wikimedia's platform. Later after this, the appellant challenged the single judge of the High Court's order, that was the 20th August order, before the division bench. On 10th October, there was another news media agency which echoed similar criticism as to how the court's decision could hamper safe harbor protection and information flow in India. Now, 14th October was the date of the hearing of the appeal that was filed in the division bench. And during the division bench appeal, the respondents, that was ANI, alleged that the publication was intended to pressurize the court. That is the two publications that were hosted. If you look at the opinion piece that was published, and then the Media Namas video that was being hosted on the platform, they were intended to pressure the court, and the appellant at this particular time sought time, and the matter was adjourned. Now, on the same day, a discussion page was hosted by the appellate's platform on the court's proceeding. So, a chat show, a talk show was hosted on Wikimedia's platform, which actually discussed the court's proceedings that were already going on. So, मुद्दे की बात यह है कि यहाँ पे जब अपील फाइल करी गई, उसी पर्टिकुलर टाइम पे एक ओपिनियन पीस और एक मीडिया नामा करके जो न्यूज एजेंसी थी उनके भी एक वीडियो जो है सेम कोर्ट प्रोसीडिंग्स को लेके उसी प्लेटफॉर्म पे था. उसके बाद जैसे ही हियरिंग हुई, उस हियरिंग की भी एक पर्टिकुलर डिस्कशन पेज को होस्ट करा गया था सेम प्लेटफॉर्म पे. ना ये सब इन सब को देखते हुए द डिवीजन बेंच ऑफ द हाई कोर्ट ऑर्डर टू थिंग्स. It observed that the critical post on appellate's platform amounted to interference with court proceeding and violated the sub judice rule. And then it directed the Wikimedia Foundation to delete the concerned content within 36 hours. नाउ ये सब होने के बाद हाई कोर्ट की जो डिवीजन बेंच थी उसने पर्टिकुलर दो ऑर्डर दिए. उन्होंने ये बोला कि जो भी मैटर रिलेटेड टू कोर्ट प्रोसीडिंग्स ऑलरेडी होस्ट किया जा चुका है इस प्लेटफॉर्म पे उसे हटाया जाए 36 आवर्स पे. एंड इसी चीज को चैलेंज करते हुए ये पर्टिकुलर अपील सुप्रीम कोर्ट में आई है. Now, any case law is incomplete if we don't go and look into the legal issues that are involved. So there were basically two major principles that were involved here. That was the principle of sub judice and the interference with the administration of justice on one hand, and then the freedom of speech and expression, the freedom of the press, and the free flow of information. तो अगर हम इन दो मेजर मुद्दों की बात करें तो ये दो लीगल इश्यूज आए थे सामने कि प्रिंसिपल ऑफ सब जुडिस और एडमिनिस्ट्रेशन ऑफ जस्टिस को कैसे फ्रीडम ऑफ स्पीच और फ्रीडम ऑफ प्रेस एंड फ्री फ्लो ऑफ इंफॉर्मेशन के साथ बैलेंस किया जाएगा. नाउ लेट अस लुक एट द डिसीजन ऑफ द कोर्ट. तो द सुप्रीम कोर्ट इन दिस केस allowed the appeal and set aside the division bench's order, and The following was the rationale that was given by the Supreme Court. First of all, the Supreme Court held that the High Court's order to direct Wikimedia to take down the Wikipedia's discussion page was disproportionate, and it emphasized that there was no real or substantial risk to the administration of justice, or the fairness of the proceedings has to be demonstrated. And two major cases were highlighted, that was the Sahara India and Reliance Petrochemical cases, in which it talked about that there should be real and substantial risk to the administration of justice, and therefore publication should be stopped at that particular stage. The second rationale that the court gave was that the court affirmed that the freedom of speech and expression under Article 1A is a fundamental right, and any restriction like takedown or censorship must pass the two tests, that is the test of proportionality and the test of necessity under Article 19 Clause 2. And the High Court's direction, both of these failed these particular tests. नाउ अगर हम इस बारे में बात करें तो जो बेसिक रैशनल जो दिया गया था वो यही था कि सबसे पहले सुप्रीम कोर्ट ने ये बोला कि जो दिल्ली हाई कोर्ट का ऑर्डर है वो डिस्प्रोपोर्शनेट है, बिकॉज ऐसा कोई रियल सब्सटैंशियल रिस्क नहीं था एडमिनिस्ट्रेशन ऑफ जस्टिस को, जो कि टेस्ट ऑलरेडी सहारा इंडिया एंड रिलायंस पेट्रोकेमिकल केस दो जो मेजर केसेस हैं उसमें सुप्रीम कोर्ट ऑलरेडी इवॉल्व कर चुका है. दूसरा, सुप्रीम कोर्ट ने ये बोला कि फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन जो है वो एक फंडामेंटल राइट है जो नहीं लिया जा सकता, और अगर कोई भी सेंसरशिप और टेक डाउन होता है तो वो दो पर्टिकुलर टेस्ट होते हैं, विच आर द टेस्ट ऑफ नेसेसिटी एंड प्रोपोर्शनैलिटी अंडर आर्टिकल क्लॉज 2, एंड हाई कोर्ट का डायरेक्शन ये दोनों ही टेस्ट फेल करता है. Now I have provided the brief of this particular case law in a very short video that I could provide, but then this particular judgment is a very good judgment to be read in order to understand what are the importance of the social media platforms and intermediaries, and how the freedom of speech has to be balanced with administration of justice. And there is some basic Obiter dicta that I have picked up from the judgment. So basically, if we go through the highlighted portion here, the court noted that open justice is the cornerstone of democracy, and that court's discussion must be open to public debate and even criticism. It also extensively cited Justice Krishna Iyer's 6 major principles that he evolved, in which how the judges should deal with contempt, and one of the major was that judges should not react with easy irritability to public criticism unless it truly threatens the administration of justice. The judgment had this very amazing line which stated that it is not the duty of the court to tell the media, delete this and take that down. Therefore, this is a powerful reinforcement of media freedom and the judicial restraint. The judgment also describes both the institution, that is media, and the judiciary as two major pillars of democracy, and for a liberal democracy to thrive, both of them must supplement each other. The court also emphasized that important issues can be publicly debated even if they are sub judice, but critics must remember that the judges cannot respond, and if such criticism has the tendency to scandalize the court and then it amounts to contempt, the courts are justified in taking action against all these criticism. एंड इन नटशेल अगर हम यही बात करें तो यही है, कोर्ट ने यही बोला कि ओपन जस्टिस बहुत इंपॉर्टेंट है और प्रॉपर डिबेट, प्रॉपर क्रिटिसिज्म होनी चाहिए, भले ही वो मैटर सब जुडिस हो, भले ही वो प्रोसीडिंग्स कोर्ट में चल रही हो, बट उसके बारे में डिस्कशन होना चाहिए. प्रॉपर फेयर क्रिटिसिज्म जरूरी है पर्टिकुलर डेमोक्रेसी में. ये ड्यूटी नहीं है कोर्ट की कि वो मीडिया को बताए कि डिलीट करा जाए इसे या उसे हटाया जाए, ये कोर्ट की रिस्पॉन्सिबिलिटी नहीं है, बिकॉज मीडिया और जुडिशरी दोनों ही डेमोक्रेसी के एक बहुत इंपॉर्टेंट पिलर्स हैं. इन दोनों को साथ में काम करना जरूरी है. पर इस बात का ध्यान ये रखना चाहिए कि क्रिटिसिज्म जो भी जुडिशरी की प्रोसीडिंग्स की जा रही है, अगर वो इस तरह से है कि वो कोर्ट की रेपुटेशन या उसको स्कैंडलाइज करती है, देन द कोर्ट हैज द रिस्पॉन्सिबिलिटी एंड दे आल्सो हैव द पावर कि वो उस चीज के खिलाफ कुछ एक्शन ले. So this was this particular case in a nutshell. So if you like this particular video, if you enjoy reading about this case, please do like, share and subscribe Law Ki Bara Khadi channel, and stay updated for more case laws and more law topics that we'll be covering. If you have any feedback to share, please do drop down in the comment section. Thank you so much for watching this video.